Hello everyone, Dwight Mitchell here again for our update. As most of you know, I am the founder of Family Preservation Foundation, and as such, I am a victim just like everyone else out here in our membership, and I am advocating for change in the child welfare system, more specifically CHIPS, or Child Protection Services, as it's known in other parts of the country. What some of you may or may not know is that I am not an attorney. I am a victim just like everyone else. Although I won my case pro se, and I'm very knowledgeable in the law, and I put out a lot of information as it relates to what can be done in Minnesota. I cannot represent you in court. I cannot come stand by you and have the judge hear me or hear anything I say. What I can do is provide you with knowledge on Minnesota state statutes, what can be done in Minnesota and subsequently in other states also. You just have to find your own statutes and case law and cross-reference into the information that I'm giving you. And hopefully it will help you if you do not have an attorney by your side as you move forward. One of the things that we have been doing, because I do understand that most of the people are low income and can't afford an attorney, which is one of the reasons I started this group, is to apply for grants. And so we've applied for 10 grants thus far in our quest to find our own attorneys to represent us. And that's something I'm going to get into later on, is why we need our own attorneys, meaning the foundation needs its own attorneys and its own litigation unit for the members. I'm going to get into that in detail, but we have not been successful in raising those funds. We're going to continue to apply in 2019 for other grants and hopefully move forward with our litigation unit, just like the NAACP and the ACLU, so that we can take on these challenges that face our members. Now, having said that, what I did want to do is share some information that I recently received from the Minnesota Judiciary. Using the Freedom of Information Act, I applied for some information because I'm trying to understand the statistics and really what's going on in the court system and how many people were treated like me and like you other members and what I hear. And so what I did find out is staggering. And what you'll see is during the past 5 years, I asked how many parents were represented by legal counsel at the CHIPS 72-hour emergency protective hearing. And if you can see this trend running along the top, from 2013 to 2014, it's anywhere between 1,000 and 1,400 parents were represented by legal counsel as an average at the EPC. And so we're saying roughly 8,000 cases are handled a year. And out of those 8,000 cases, that's about 40,000 cases over the course of 5 years. And only approximately 6,699 parents actually had counsel at the EPC. Like myself, I think most of you receive a summons, you come to the meeting and you start learning all of the things that you're supposed to learn, or in fact that you don't learn, all the things that they hide from you. Then I went on to further ask. I said, well, during the past 5 years, how many people had attorneys at the admit-deny hearing, which is 10 days later? And so, the numbers here have jumped up, not significantly, but they pretty much doubled across the board. So the people that had legal counsel or didn't have it, at least at the admit-deny hearing, a significant number had legal counsel, but as a percentage of the total of 40,000 cases, approximately 40,000 cases that went to the admit-deny hearing and went further, only about 16,000 people had attorneys. That's not even half. That's about a third of the people. So that's not good at all either. So you're standing there, having to admit or deny to the allegations that CHIPS is putting forth, and or rather CPS is putting forward, without legal counsel. and so that's another thing that I'm going to discuss, why that's a hindrance to the parents. But finally, one of the things that most parents don't know and they don't realize, and it's very, very important, I wasn't even aware of this until after the fact, is that when your children are removed from your household, by law, by Minnesota statutes, the government has to bring that case to trial within 60 days of the admit-deny hearing, so that once you have that admit-deny hearing, the state is required to present proof, evidence, not just allegations. And so we're going to talk about the difference between allegations and evidence, because a lot of people get caught up on, CPS is lying. And I'm like, well, we can discuss that in further detail. But, in total, only 488 cases were brought to trial in the 60 days that, is required by law out of 40,000 cases in 5 years. So that's abysmal. That really tells you what is going on and how CPS is truly getting away with just heinous acts. Just the whole judiciary. I'm not going to say it's CPS because the judges are allowing it to happen. And as I go through this, you'll understand what I'm talking about. So some of you ask, well, why did I ask these questions? Well, the Minnesota statutes say that the parents are entitled to have an attorney at the EPC hearings to advocate for them, to defend them. But what the Minnesota rules of juvenile protection do is they say that CPS doesn't have to file the petition until the day of the hearing. So how are you supposed to defend yourself against allegations or present evidence or even come to court with evidence or even come to court with an attorney when you're not even given the petition to the day of the attorney? That very first hearing is a violation of our constitutional rights. And that's one of the things that Judge Wright brought up if you were at the oral arguments October 9th. She asked, did the parents have attorneys, at the EPC hearings? And, almost everybody in the audience was just like shaking their head like, no. And I didn't have one, and I don't think I know anyone that had one, because no one is really given the information like, all right, I'm going to get an attorney when I don't even know what I've done or what the allegations are against me. I'm not so sure. I mean, I saw the numbers. They were saying about 1,000 people a year had attorneys out of about 8,000. That's still only like an eighth of the people came to the EPC with attorneys. But if it was like myself, I got a letter the day before telling me I had to show up to the EPC hearing. I couldn't get an attorney overnight, a family law, to even become involved, let alone go with me. Like, what attorney is free? Any attorney who's just can just say, sure, I'll show up at court tomorrow. Well, he's not a very busy attorney, or he's not doing what he's supposed to be doing. So just that single act from the commencement of the proceedings tells you, what's going on as far as trickery and the whole process being a sham. Now, 10 days later, they had the submit-deny hearing. And so here's something else that's very, very important that most people are not aware of. And I wasn't at first also until I started reading the juvenile rules of procedure and what the state statutes were. So the admit-deny hearing is where you as a parent must either admit to the allegations that CPS is bringing forward or deny. And here again, you're supposed to have legal counsel. So now you're supposed to have read the petition and you can say, this is true or this is not true. So what's really important that most people don't understand at that EPC hearing, and the reason you need an attorney, and also at the admit-deny, at the EPC, that's where you're supposed to present evidence to say, no, my child doesn't need to be removed. I've done nothing wrong, or these allegations are false, and here's the evidence for me to supply. And then the judge could say, okay, well, the prima facie has been established, so we're still going to have a case or go to trial, but the child doesn't need to be removed because there's no danger to the child if the child remains in the home. And the admit-deny hearing, when we come to that phase, which is about 10 days later, you have the evidence to admit or deny, but also to ask for a motion to dismiss, to present evidence again, to bring, a doctor to trial or court to testify on your behalf to say, listen, the prima facie says that my child had a bruise and I did the bruise. And the doctor is saying, no, that bruise was caused by the child falling down, or the child is easily bruised, and I knew about the bruise, and here's why. But so here again, it's very important at that admit deny that you have an attorney with you or someone that can file that motion to dismiss to try and take the prima facie and to present evidence to cancel it out. So what a lot of people don't realize is a prima facie is it's Latin for at first look or at first glance. And so what that means is that if the allegations that CPS puts together are true and they're not rebutted by evidence, then this would, provide a means for CPS to be involved in your life. So based on the allegations, if you can put forth facts that cancel out, those allegations, then the judge can dismiss the whole case at the outset without you having to go to trial. Otherwise, you'll have to go to trial in 60 days. This means the allegations are accepted as correct, not that they are, they're allegations. And allegations mean, they're claims or assertions that someone may have done something illegal or something wrong. It's not saying that you have actually done it. So when people are like, oh, they're lying against me, well, they're not. They have to prove these things. They're just allegations. And so they can't prove them unless A, you've actually done them and it's valid, or B, you help them. And so that's something else that most people do. They talk too much. And when I say you talk too much, it's just like you are not required by law to help them prove their case. You are not to help them prove their allegations. You do not have to talk to them. You should remain silent, which most people don't. You do not have to allow them in your home. You do not have to sign consent. And so we're going to go over this later on, not in this particular video, but I have a CPS 101 video that's coming out next. That's all written up and completed. What I really need to do is just to film that one. So that one should be coming out fairly soon. But I'm going to give you an example. It's just like a CPS alleges that your child is mentally ill and could die, and so your child needs to be removed from your home, and you're like, my child is 100% healthy, and you bring the doctor to court with you, and the doctor tells the judge, Your Honor, this child is 100% healthy. I checked this child out yesterday or the day before, and there's nothing wrong with this child. That cancels out the case. So what Minnesota Statute 260C.503 subsection 3D says is that the trial must come to trial. I'm sorry, the case must come to trial within 60 days of the admit deny hearing, and it must finish within 30 days. So, as I stated earlier, only 448 cases out of 40,000 actually did this. So there's a problem with the system, as we all know, but most of the problem is that the judiciary and CPS are taking advantage of you because you don't understand, and you don't understand the rules of procedure, and you don't know the timeline. Now, the timeline has been out on our website. I don't know if people have looked at it, but it's been in the file section for 8 months now. And I've told people repeatedly, go look at the timeline. It's a color PDF that says when things are supposed to happen and in what time frame. And it gives you the statutes. So I put this out there as a cheat sheet for everyone, because this is one of the most important things about the process. And if you read my PDF that's attached at the top of the page, our group page and our Facebook page, that tells you about that guideline also and that time frame. So you should look at that and pay particularly careful attention to that. So, we're sitting here saying, well, why are all these things taking place? And that's because no one is fighting for the constitutional rights of the children or the parents. And this has been going on for well over 20 years. And when I say well over 20 years, it's been going on for longer than 20 years. But, there's at some point you have to cut things off. And when I say cut things off, I go back 10 years and sometimes I'll go back 20, and I'm trying to determine, just how long this is going on. And so CPS actually has been allowed to continue operating in this fashion out of compliance with state and federal government for about 20 years. And the fact that they have been allowed to do this for such a long time is just mind-boggling. Coming to understand all the federal funding and everything that's going on, and how CPS right now across the United States is a self-protecting machine. By seizing children illegally in violation of the Title 4E requirements that include the filing of federal documents in secrecy. So there's a number of documents that have to be filed by the federal government to ensure that the states are in compliance. And what most people don't realize, and I didn't realize it either, is that these boxes that they're checking on the forms that are saying, the child can't remain in a home safely, and it's just like 3 boxes there that the judge ticks. So you're in court between the EPC hearing and the admit-deny, and the judge is checking these boxes when you don't even have an attorney present to advise you on what's being asked and answered. And so, in reality, CPS should be held liable for its illegal actions, and restitution should be made, and the funds that have been obtained through the federal government illegally, and they should be prosecuted for perjury, obstruction of justice, and the fraudulent collecting of federal funds under the False Statements and Assembly Accountability Act of 1996. So what's interesting, what I found during my reading, is that this has been a topic since about 1998, and the Inspector General has actually looked into this, and the Inspector General felt that CPS could be prosecuted under the RICO Act, yet they failed to act on this. And one has to understand why, and one has to wonder why the federal government has failed to act on this. And what I came to find out is one of the main reasons that the Attorney General has not acted upon this is because in order to go after CPS and DHS for the illegal activities for committing the federal fraud, they would also have to go after the judges who are signing all the documents for CPS to get these funds, who are saying they validated that these things are in fact accurate. So you're sitting here saying, well, why isn't anything changing? Well, it's not changing because they'd have to go after all of the judges in all of the states, as well as CPS in all of the states. And CPS in most states, it's like the 3rd or the 4th, like in Minnesota. DHS is the 4th largest administration body in all of Minnesota. So, right now we're going after one of the big dogs. Their budget is $15.9 billion a year. That's what Minnesota DHS's budget is. And it's the same pretty much across the board in all of the states. So in order to go after them for collecting all this illegal money from the federal government, they'd have to go after all the judges also. So our whole judiciary would come to a grinding halt. So that's one of the main problems. So I'm going to read you something right now that I read, obtained from the FBI files, and it was mind-boggling when I read this. So I feel I'll read it to you also. In 1998, George Miller was the chairman of the Congressional Appointed Select Committee on Child, Youth, and Families, and he recognized the fraud being committed in the name of child protection and stated, quote, "What has been demonstrated here is that you have a system that is simply in contempt. This system has been sued and sued. Orders have been issued, and they just continue on their merry way. And HHS, which is the Health and Human Services, just continue to look the other way. You have a system that is not only out of control, it's illegal at this point. What you are really engaged in is state-sponsored child abuse." This is from the FBI investigating the CPS office in September 14th, 2008 at 3 p.m. So this was taken directly out of the files. And so don't think that what's going on is something unique to you and unique to me. It was actually rather sobering when I saw what was going on and the fight we'd have to go against. And so this is one of the primary reasons that I'm advocating for our own legal defense fund, because I see now we are fighting a machine that Congress, the United States Congress, our senators and congressmen can't get it under control. It's become so powerful and so out of control at $250 billion a year that in order to correct it, we'd have to get rid of all of the judges and everyone else associated with this. So I'm saying, okay, well, what do we do? And so I said, well, where does that leave us with this current system, and how do we overcome it? So, when we look at lawyers and we look at what's going on, no one's going to help you for free. I'm just going to call a cow a cow. You can look, I said, but you get what you pay for in our world, and that's just that. First and foremost, private lawyers are in business, and they're in business to make money. That's just what it is. I mean, they have family support and they have things to do. Just like you have to work a job. That's their job. They make their money by opening cases and billing clients. If the clients can't pay, they drop them like a hot rock. That's just the reality of how things go. Second, the attorneys must continue to work in the same system and go before the same judges again and again, year after year. And they don't want their reputations being tarnished, or even people saying, well, oh, he's difficult, or he's anti-system. And they don't want to upset the judge, because this judge has to rule, for them in other cases. And so they're sitting here not wanting to offend the county attorneys and offend the judges, because they're like, well, I won't be able to make a living if I do this. So that's another major issue with hiring private attorneys. And you get some like Rhea Borman, who has a lot of integrity and really cares about the family, and she's just like, I'm just gonna have to have that name as being a tough lawyer who stands up to judges, and I'm fighting for my parents because that's the right thing to do, and that's what the Constitution says we're supposed to do, and I'm honoring my oath and my ethics as an attorney. But, as most of you have come to learn, attorneys like Rhea Borman are few and far in between. So, what do we do? Most people know who Albert Einstein is, and, Albert Einstein's definition of insanity is doing the same thing over and over again and expecting a different result. So I'm saying to you, you can't keep going, to the same attorneys in the same system expecting a different result. It's just not going to happen. You need a paradigm shift. Something needs to happen outside of the way it's currently being done. And going to private attorneys who only care about themselves and who are afraid of the judges and afraid of upsetting the county attorneys, and who are doing ex parte conversations, with the other members of the judiciary, is not the way to do it. Which brings me back to why I say our foundation needs to hire our own lawyers. We need to be like the NAACP and the ACLU. So this is one of the reasons that I wish to form the foundation litigation unit, So, our FFL will be just for our FPF members. And when I say that, the charter that I currently have drawn up will provide that the mission of the litigation unit is to conduct litigation to the benefit of FPF members and to pursue law reform and promote the welfare of children and families and the well-being of families. So, our cases are going to be selected, on a basis that raise constitutional issues, as we've already done, and it benefits a large number of children and families in the state of Minnesota. So the only thing that we do is child protection. So the FFL would also educate the public and conduct legal advocacy, but we're not lobbying. We're just advocating change, and we're trying to get the message out. So what a lot of you don't realize is that our board of directors we can't select the individual cases, but we put the policy in place, and our charter states, what the mission is. So we have the ability to monitor, the FFL and the attorneys, and to ensure that they're following our litigation priorities of the foundation. Two, we get to approve the performance requirements and monitor to whether they have been doing what they were hired to do, and are they achieving successes? Similar to the Amanda Weber, we've already proven if I get attorneys, we're going to rock and roll just like Amanda Weber's case, and we're going to put things out there, and we're going to win. So, and we also have the ability to evaluate the staff. So, we have full-time attorneys, and their whole job is to fight for the families in CPS cases. So we're going to evaluate. Are you being successful? Are you winning? If not, we're going to replace you with another attorney. I mean, it's, while we can't tell an attorney what to do, we set out our guidelines and our policies and procedures, and we're like, you have to follow everything by the book. If it says you can enter a motion to dismiss and within 10 days or before the admit deny, you will enter that motion to dismiss. If, you will be at the EPC hearing, you'll advocate and try and cancel out all prima facie allegations, and all allegations must be proven. You're gonna tell our clients, do not talk to CPS, keep your mouth shut, do not let them in your house, do not do drug tests. What most people don't realize is you can't prove anything to EPS to CPS. Once the allegations are out, the allegations are out. Everyone thinks they can talk their way out of it, or I'm going to prove to them. No, you can't. And just stop. If I could say anything to all you parents, just stop, because you can't talk your way out of this. The law is pretty straightforward, and it's specific. It says, here's what needs to happen. Here's the Minnesota rules of procedure, and here's what you're going to do. And so that is something that needs to take place a certain way. And if you could present it yourself, superb. You can do that. But most people don't have that ability. Now, having said all this, the option is really up to the members. I mean, I'm a member just like everyone else, although I put this foundation together and this group together. I'm a member, and if the members don't want to hire, attorneys, then we don't hire attorneys. That's really where we are. If we can't afford an attorneys, we can't afford an attorneys. But I sit here and I look at, organizations like the NAACP and the ACLU, and they all have low-income people, yet they have their litigation units. I'm like, we have a choice. We either pool our money together and act like the NAACP and ACLU to affect change, or we continue to be abused by the system. Our one federal case, that will help for constitutional rights violations, but the legislature still has to be changed, and attorneys still need to fight within the same construct. Because if you think that if we win that lawsuit, that CPS is just going to stop and they're just not going to continue to try and get the federal funding, you're only fooling yourself. We're still going to need, lawyers with integrity to stand up, for the parents and fight for their constitutional rights. So, at least if we have FPS attorneys who work under, our FPF charter and our guidelines to ensure the statutes are followed, evidence is presented quickly, and parents, are protected and they have a right to be heard. And so there's no more of this, CPS coming in and just steamrolling, over the parents. Studies have proven that parents that have a good lawyer, it reduces the amount of time that kids are in out-of-home placement, or you're dealing with CPS. In New York City, the Center for Family Preservation, which similar to myself, contact lawyers and who specialize in child welfare law and put them together with parents. They did a study and they found out that children whose parents they helped were involved in CPS about a third of the time that they were without CPS. So the average child was in out-of-home placement for over a year when they didn't have proper legal representation. After today, I'm not going to mention this anymore. I'm going to keep putting out videos trying to help people. But I'm here to tell you the only way that we're going to affect change, meaningful change, is to have foundation lawyers where their sole charter is working for the members. And, I'm starting in Minnesota because that's where this whole thing started. I can't start in all 50 states at the same time, but I feel if one state rolls, then it's like a domino effect and the other states start rolling also. So, we filed the federal court case here, and, we established an office here, and I'm going to try and get foundation law unit going here. And if it works here, then that model can be replicated as we go across the United States. So just keep in mind, what we're trying to do. If you feel it's something we can accomplish, super. Everyone keeps forgetting, and I don't know, I find it interesting when I get comments from people, and what people don't seem to understand, or I don't know, maybe they do, maybe they don't, but what you really don't understand is I already have my kids back. I've had my kids back for 3 years. I'm trying to help you. Now, if you don't want to be helped, there's nothing I can do. I can lead a horse to water, but I can't make the horse drink. I can tell you what needs to be done and what you need to do in order to be more effective, to be a cohesive unit, and to fight back. And you can either do it or you can't do it, or you want to do it. I mean, everybody wants to go their own way, but then you can't, come on the board and cry and say no one's helping me. You really only have one or two choices, maybe even three. Choice number one, let the system continue to do what the system is doing to you. Choice number two, go at it yourself pro se and hope you're successful like I was, but that takes a lot of studying and a lot of hard work because they're going to try and steamroller you. Or three, get together collectively as an organization, as a body, hire attorneys. One attorney can do about 50 cases a month, as the cases roll. So, and when I say as the cases roll, he can actually probably handle about 50 before it starts to become overwhelming, somewhere between 40 and 50. So if you have 2 or 3 lawyers, you start multiplying that out. If you want to just start with one and say, okay, we'll do one lawyer is about $75,000. If you take the number of people in this group and you say, okay, everybody, we're going to put in this much money. We're going to put it in escrow. So we're going to have an attorney take the money, put it in escrow, and it's just for the attorney fees. So it can't be used for anything else but the attorney. And then we're going to say, okay, let's see, if we can get this going and how this works. And so the attorney's, monthly salary is paid out of the escrow fund, and the money can't be used for anything else. And then we're going to sit here and track what's being done and how the cases are actually going. And we're going to make sure that all these cases are brought to trial in 60 days. So if we're bringing the cases to trial within 60 days, we're not dragging things out like a year. And what a lot of people don't really understand is they don't have to do anything until after the trial. The trial is the key point. That says whether or not the child is in need of protection or services and what needs to be done and what you need to do. And that's the only time the judge can order you to do something. He can order you to do a drug test or to participate in some counseling or some therapy, your kids in therapy. Prior to that, he cannot order you to do anything. It's all volunteer, and that's what everyone needs to truly understand. You need to read and really understand that and stop letting them threaten you, because it is weak, empty threats. They can lie, put all the false allegations they want into the mix, but in reality, if that trial comes down in 60 days and they don't have the evidence, then guess what? They can't prove their facts. The case gets dismissed. They can say that your child needs food or your child needs housing. Well, they have to prove that your house is bad. They can't prove it if they can't get into your house. And there's no lawsuit that says that you have to let them into your house. If anything, if they come with an emergency removal and say, we have to remove your children, take your child to the door and get the warrant and then give them the child, because you can't win. All they're going to do is kick in the door. The police are going to, it's going to become messy, and you can't win that fight. You know, you can talk about your constitutional rights. You can video record it. I can't tell you how many times I've seen video recordings of the police coming in with CPS and snatching the kids, and nothing happens. And it happens time and time again. And, you know, I'm not trying to be disparaging. I'm just trying to tell you the facts of life and how we can combat that and what we need to do. And for God's sake, people, stop taking tests and stop signing forms before the trial. They say, we want you to take a drug test. Say, no, you said I'm using drugs, so prove it. Guess what? They can't. They say your house is messy. Don't let them in your house. How are they going to prove it? They can't. So you got to remember that you don't have to sign, no matter what they say. The only thing that they have to do by state statute is give you visitation. And if they don't give you visitation, you write to the county attorney, you get it stamped that they received it, you file it with the court that you're requesting visitation, and by law they have to give it to you. Unless the only way they don't have to give it to you is if you do egregious harm to your child or you sexually assault your child. Other than that, it's mandatory. So they could say, well, we're not giving to you, sign these forms. That is not the law. And we'll talk about that later on also. I can go on and on, but I have so many more of these videos that I'm going to put together for the group. Hopefully trying to help. I'd like to get out one a week, but I don't think that's realistic. You know, I have a family. I work full time. You know, I try and do some work in the evenings, but it just it's not happening. I got a 10-month-old, and you know, maybe I can do one a weekend or one every other week. But my next one coming up is going to be called CPS 101, and I'm going to give everyone a complete breakdown. It's a 40-page presentation that I put together. So I'm going to take you through that entire presentation so that you all have an understanding of, you know, the entire process. And that's what a lot of people really don't understand. I've broken everything out into certain sections, and we'll talk about that also. So you really need to understand, you know, the EPC, the hearing, the trial, what happens after the trial, and all the things you need to do to protect yourself, because CPS does not care about you. They only care about the federal funding. Our blog is starting up, and that will be on the FPF website, and I'll start shooting out links to that. But I'm going to be showing everyone that this is not new news. This is old. It's been going on a long time. They've been trying to fight it a long time, and no matter what the senators and congressmen do, this machine still keeps rolling. So the only thing we can do is fight back as best we can, and that's by using the law effectively and having good legal representation that works for the members, that works for you and only you. You know, we're paying them a salary. They're not getting, you know, money based upon how long the case is open or what's done. So their whole goal is to do the right thing, like get rid of the case, 60 days, out the door, let's go, on to the next one. And so that's what I'm trying to do for everyone. Well, it's Dwight Mitchell signing off once again. I hope you found this video informative, and keep in touch. Thank you very much. Have a great day.